Okay, I am live. Welcome, everyone. Welcome to this Q&A session on employment law. I'm Lior Samfiru, the employment lawyer. You know me, you've seen me before. And why am I here? Well, I'm here to answer your questions, live answering questions about employment law, about workplace rights. So again, I'm the employment lawyer, Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. We operate across Ontario, BC, and Alberta. So if you're in one of those provinces, you have a question about your workplace rights, you want to know about what your rights are, what the law does for you, well, ask the question right now. I'll see it, I'll answer it, and you can walk away with that knowledge. So don't be bashful, don't hesitate. This session is for you. I already know my employment law rights. I want to make sure that you know your rights. If it's a question about a situation where you've just been let go and you lost your job, your employer is telling you that you have to accept something, do you, should you, what does it all mean to ask? I'll tell you. If it's a question about your employer putting you on a temporary layoff, can they do that? Should you accept? How do you respond? I'll tell you. Maybe you're being bullied or mistreated in the workplace, harassment. Ask the question, what can you do about it? I'll tell you. Of course, maybe your job has changed, your hours, your compensation, your days of work. If that's the issue, I can tell you what to do about that as well. If it falls under the rubric of employment law, workplace rights, you're looking at the right session right now, and I can answer your questions. Again, I'm Lior Samfiru, the employment lawyer. You have an opportunity to type in your question, press enter. I'll see it, I'll read it, and I'll answer it. Of course, if you want to connect with me and my team off social media, off air, if you want to have a private chat, a private email discussion, easy to do that. All you do is you go to employmentlawyer.ca. You'll see that address on the screen right now, employmentlawyer.ca. And you can connect with me through that website. Phone number is there, email address is there. If you prefer to fill out a form and we'll call you, it's all there, employmentlawyer.ca. But that's for after. Right now, I'm live, you're live, so let's get some questions answered. Don't be bashful, ask your question. First question, I love having our regular viewers on. N. Stinson, a regular viewer, asks a question. What legal protection is there for employees once you are retained, send a demand letter? Some employers retaliate against employees in various ways, such as abusing the performance review or work assignment process. Well, no, I think you're misunderstanding, because usually we only get involved when someone is no longer working for the company. Now, there could be situations where we may get involved with the person who's working, but that's rare. Usually when we get involved, it's where the person is no longer working for the company. They've been let go, or it's a constructive dismissal, resignation. So there's nothing the employer can do to the employee at that point, because they're no longer working there. The other thing is this: it's illegal for an employer to punish someone because they're standing up for their legal rights. We call that a reprisal. In fact, that's the topic that I wanted to address today, which I will in a few minutes. The idea of reprisal, which is the law says that an employer that punishes, mistreats, bullies an employee because that employee was standing up for their rights, that employer is guilty of a very big legal violation that could be significant repercussions. So honestly, I haven't seen that happen. It's a non-issue. I would not worry about it. Don't ever hesitate to make the call to myself, to my team, because you're worried about your employer's response. That's the last thing you should be worried about. What you should be always concerned about is ensuring that your rights are enforced. Okay? Hopefully that answers the question. All right, guys, ask questions as well. We have time. You have time. If you want to know something about your legal rights, what a great opportunity you have to ask. I'm the employment lawyer, Lior Samfiru, with Samfiru Tumarkin LLP, live here for you at your service. All right, let's see. Our next question comes from Arnold. My employer wants me to complete some company training, but has asked me to do it on my own time after work hours. Are they allowed to do this, or should they provide me with time during the day to complete this? Your employer cannot expect you to do work stuff for free. Cannot. So if they're saying you need to do this, that's work. Okay? And if you do this, they have to pay you for it. So they cannot expect you to do this on your time. Now, keep in mind, even if they pay you, they can't expect you to do it after work hours. Okay? So if your regular hours are 9 to 5, they can't say, well, you need to do this training at 7. We'll pay you, but you have to do it at 7. No, because it's not your work day. So if your employer needs you to do this training, number one, they have to pay you for it, number one. Number two is they have to do it during your working hours. Now, they can give you an incentive. They can say, we'll pay you time and a half if you do it after hours. And if you agree, that's great. But other than that, no, they cannot expect you to work after hours just because of something that they want you to do. So great question, and hopefully that helps. Any follow-up, you know what to do. You reach out to me through employmentlawyer.ca. Okay, great question. Next question. Actually, it's the one that I get often, and that's from Kelly on YouTube. Kelly asks, is there a difference between severance pay and termination pay? So it doesn't matter. Let me kind of explain what I mean by that. There may be a difference, but at the end of the day, it's irrelevant. What matters is the amount, the total amount that you're owed if you lost your job. That amount may be comprised of termination pay and severance pay, but who cares? At the end of the day, it's a question of the total amount that you're owed. We usually use a generic term for that, severance. So when I talk about severance, that may actually be severance plus termination pay, but it doesn't matter. So when I say you're owed 6 months severance, that's what matters. It doesn't matter if 2 of that is termination pay and 2.5 is something else. What matters is that you're owed 6 months. So don't waste your time figuring out the difference between termination and severance. Figure out the amount that you're totally owed. And by the way, let me give you a way to do that, of course. If you want to know the total amount you're owed, regardless of what it's comprised of, easy. If you lost your job, you can go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Why do you go there? Well, you go there because we have our severance calculator tool there. Our severance calculator tool allows you to find out in seconds for free how much you are owed, the total amount that you're owed if you lost your job. Doesn't matter if you worked for 2 months or 25 years. If you lost your job, you can find out there by answering a few questions anonymously, no names, no company's name, no credit card numbers, no email address, nothing. It's just there for your benefit. pocketemploymentlawyer.ca. You'll be surprised by just how much you're owed. If you think okay, I think that if I'm let go, I'll be owed this amount. Well, keep that amount in mind and then go use our severance calculator and do the calculation. I bet you anything that the real amount, the actual legal amount that you're owed is going to be a lot higher than the amount that you had in your head. Okay? Let me know, by the way, in the comments if you've done that. I'd be curious to know if I'm right. I bet you anything that I am. So pocketemploymentlawyer.ca, use our severance calculator. Okay, follow-up from N. Stinson. I was thinking of a case where you are retained to send a letter to an employer who demands the employee return to office in person, so still employed. No, I wouldn't send a demand letter in that situation. I would just tell your employer that you're not doing it. That's it. And then if the employer wants to let the person go, they can. I can't stop them. They have to pay them severance. There would be no need for me to be involved in that situation. I would just tell the employee what to do, right? Guys, we are live right now. So if you're wondering about your employment law rights, you still have plenty of time to ask your question, just like we've been getting some questions already, but you have time. Type it in, press enter, give me the chance to read it and answer you. So when you turn off your computer, you'll say, aha, now I know. Now I'm educated about my legal rights. Take advantage of that. I'm here and I can talk about employment law all day long, but I would rather answer your questions. I would rather talk about what you want me to talk about. So if you're struggling with something or if you're always wondered about something, I'm here, Lior Samfiru, the employment lawyer, answering questions. All right, let's see. Next question comes from Anne on YouTube. I was reading online that you have to have worked for more than 5 years to be eligible for severance. Is this true? No, it's not. Every employee is owed severance, whether you work for 5 years, 5 months, 5 weeks, you name it. Yes, you are owed severance. It's very simple. If you had a job and you lost your job, you are owed severance. Now, your minimum entitlements may be different whether you've worked for 5 years or longer or shorter, but your full entitlements are going to be the same. It doesn't matter. In fact, even if you work for a company for a few months, 6 months, let's say, you could be owed several months severance, not several days, not several weeks, several months. In fact, short service employees, and I'm sure you've heard me say this before, short service employees are treated disproportionately better than long service employees. So someone that's worked for a few months usually is going to be owed a few months severance. Sometimes the length of the severance can be greater than the length of employment. Okay, so no, there is no 5-year threshold for severance, not even close. Again, I'm going to point you to our severance calculator at pocketemploymentlawyer.ca. Check it out. Whether you work for 5 days, 50 years, or anything in between, check it out and find out how much you're owed. Thank you for that question, Anne. Continuing to answer questions. Let's see. Melly on YouTube. I work for a small cleaning company, but cannot continue to work for this employer. I want to start my own business, and my clients want me to continue cleaning for them. If I leave and take clients, can my employer take legal action against me? I have not signed any agreements. Then no, the answer is you cannot. Well, they can always take legal action against you. Anyone can sue anyone, but they would have no basis, no legal basis to do that if you didn't sign an agreement that that prohibits you from doing that. What you don't want to do is you don't want to approach clients while you're still working for the company, because you have to act in the company's best interest while you work for the company. But if you quit and then you contact your former clients, yeah, you can do that, again, as long as you didn't sign any agreement. So don't contact the companies, the clients, while you're working, saying, hey, in a month I'm leaving, so come with me. That would be improper. But you can absolutely leave and then call them and say, hey, I've left, I have another business, I want you to work with me. That's absolutely fine. Nothing wrong with that. All right. Great questions today. Let's see. Next question comes from Ashley on YouTube. Okay. Ashley has a comment, not a question. She says, these guys are great. I've watched a few of these lives and have had some very helpful advice. Thank you for all your help. Well, you're very welcome, Ashley, and thank you for your comments. That's very nice to hear. And I'm glad you found these useful. Always feel free to contact us either here or through employmentlawyer.ca. Same with you at home. If you want to connect with me, you see that address on the screen, employmentlawyer.ca. It's the gateway for everything and anything employment law. You can contact me and my team through there. But that's for after the session. Right now, during this session, I'm still here. I'm still live answering your questions. So don't be bashful. Ask your question. If you're watching me right now and you're not asking me a question, ask yourself why. Why not take advantage of me being here, encouraging you to ask me a question? So I'll continue. Next question from Sean on YouTube. I'm on a medical leave because of a toxic work environment. Do I have to return to my job to see if they have made any changes? Then if the bullying and toxic environment is still a problem, I can try to leave and ask for severance. Generally speaking, yes. So what I want you to do is I want you to, if you haven't already, I want you to tell your employer, here's my concerns. This person was mistreating me or bullying me. I want you to do something about it. If they say, come back, we've dealt with it, go back. If things are resolved, great. If they're not resolved, if you're still being bullied, mistreated, document it. Either record or write things down as they happen. Have some record. And then, yes, that could be a constructive dismissal. It could even potentially be a human rights violation. You can leave with severance. But you want to give the company the opportunity to fix the problem, okay? You want to give them the chance to say, here's the issue, you deal with the company. Because you don't want the company later on to say, hey, you never told us. We didn't know. If you had told us, we would have dealt with it. You want to tell them in writing, okay? Always have a record of it. Here's the issue, here's the problem, please help me. If they help you, great. If they don't, then yes, I can get involved right away, but always give that company the opportunity to fix that problem. Thank you for that question, Sean. Very good, and I wish you good health. Again, I'm Lior Samfiru, the employment lawyer here, answering your questions live at your service. So you know what to do, whether on YouTube, on Facebook, on LinkedIn. If you have a question, you know where to ask it. You type it in, you press enter, and I'll see it. All right, let's see. Jay on YouTube. I'm a gig worker in BC. Position was eliminated by my employer. I was offered work that is quite different. If I try it out, how do I mitigate the risk of severance loss if I find it is not for me? So very important. If you're being offered a different job, but you don't want to necessarily want your employer that's what you're doing, send them an email or even a text message saying, I'm not sure I'm comfortable with this new position. but I'm going to try it for the next 3 weeks and see how it goes. So put that in writing. And then you try it for the next 3 weeks. If everything is good, fine, great. If it's not good, you still haven't compromised your severance because you told your employer that what you're doing is you're trying it out. You haven't accepted, you just want to see how it goes. So tell your employer, put that in writing, email, text message, something in writing, and try it out. Generally, I wouldn't want you to try it out for more than a month, tops, okay? 2, 3, maybe 4 weeks, that's it. And after that, if you're comfortable, you're good, you continue working. If it's not good, if it's not something you're okay with, call me before you do anything, and we need to talk about constructive dismissal. Of course, constructive dismissal is a situation where your employer has made significant changes to the terms of your employment, and you choose to leave as a result. The law considers that to be a termination. Your employer can't just change the terms of your employment. They can demote you, give you a pay cut, change your shifts. If they do that, you can consider that potentially a termination and leave and require the company to pay severance. Okay, so that's when that happens. All right, great questions today, guys. Excellent questions. So ask yours as well. Don't hesitate. You've got a bit more time, not a lot, but a bit more. So ask your question. Let's see. Daryl. Yeah, Daryl has the next question. I was off for 3 months on short-term disability. I was denied my yearly bonus. I was told it was because I took those 3 months off. Can you be penalized for taking the time off? Well, no, you can't be penalized, but it's also a question of how's the bonus calculated, okay? If the bonus is based exclusively on company performance, you have to get the bonus. If the bonus is based on your performance, well, it's a question of can they measure your performance based on the time that you were off? If they can, they should pay you the bonus, or at least a prorated portion of it. Bottom line is you can't be punished just because you were sick, okay? But if the work wasn't done to justify the bonus, even though it's not your fault, it's also not the company's fault. But if you did the work to justify the bonus, they can refuse to pay it to you just because you're not there, okay? So hopefully that makes sense. Any issues with that, contact me, of course, through employmentlawyer.ca. Again, employmentlawyer.ca to connect with me and my team, always off air to have a private discussion, to get me and my team to roll up our sleeves and get to work for you. Again, employmentlawyer.ca. Right now, I'm still live. Lior Samfiru, the employment lawyer, answering your questions. Next question. Best name of the day so far. Radio Dramatic. Love that name. Prior to the pandemic, I spoke to my manager about remote work options and was told that I could move anywhere in the province and could work remotely. I moved over an hour away. Now my employer has instituted a recall for all remote workers. Since my employer agreed to this arrangement prior to the pandemic, would this be a constructive dismissal? Well, it wouldn't actually be a constructive dismissal. If they let you go because you're not back, it'll be an actual dismissal. So you can tell your employer, no, I mean, you told me it's fine, so I'm not coming into work. We had a deal, so I'm going to continue working. At that point, your employer is going to do one of two things. Either they'll back off and leave you be and let you continue working remotely, or they're going to let you go. Now, if they let you go, of course, they have to pay you severance. And remember, an employer can let you go pretty much for any reason as long as they pay severance. So they can let you go, but they have to pay severance. They can't say that, well, your refusal to come in means we don't have to pay you severance. Absolutely not. So it wouldn't be a constructive dismissal. It would be a regular dismissal. So that's what happens in that situation. I would simply, if you're not comfortable, you tell your employer, no, I'm not doing that. But there is a chance they'll let you go, right? They can let you go for any reason. But of course, they have to pay your severance. And, I don't know how long you've worked there, but you can find out now how much you're owed, of course. Just go to pocketemploymentlawyer.ca. You see that address below me, pocketemploymentlawyer.ca, and use our severance calculator. All right, Kevin on Facebook has our next question. My employer has requested a medical update on my absence. I have given 2 of these recently while on short-term disability. Now I'm on long-term disability. They have requested another medical update. I don't understand because since I'm on my employer's insurance, don't they know I'll be absent and my insurer has received my medical update from my doctor? So generally speaking, the insurance company is not going to share your medical information with your employer, okay? It's something that they use, and they're not going to share that. So it's okay for your employer, now that you've switched to long-term disability, to give an update. And the update could simply be from your doctor saying, there's no update. Things are exactly as I told you in my last letter, and that's fine. So I'm only saying that if you were still on short-term disability, I would say it's too much for them to ask for another update. But because you switched to long-term disability, it's okay for your employer to ask for that update. And the one thing I want you to your doctor not to say, I don't want your doctor to say that you will never be able to come back to work. If your doctor says that to your employer, they can potentially terminate your employment for what we call frustration of contract. Your doctor simply has to say you're unable to work, and will continue to evaluate your ability to come back in the future. That's it. That's all they have to say. They don't need to be specific. They don't need to know what your medical condition is. They don't have a right to know what treatment you're getting, what medication you're on. Just that you cannot work, and you'll continue to be evaluated, and we'll keep them up to date. So Kevin, hopefully that helps. If you have any follow-up questions, ask them. Happy to answer. So let's see. And Stinson says, some companies are very vengeful via bad future performance reviews against employees who say no in the manner you described. Again, you cannot so we have a concept called reprisal. A reprisal is a situation, is a term that means that your employer is punishing you for standing up for your rights, for asking questions about your rights, for trying to enforce your rights. It's illegal. So an employer that does that may have to pay fines, penalties. If they let go of an employee, they may have to hire them back with back pay. So it's a very big deal. So if you find that your employer is punishing you in any way, mistreating you, putting you down, harassing you, making up stuff because you're standing up for your rights, call me, okay? Let me know about that. I can help with that. The law takes that very, very seriously. You see the address below. To connect with me, of course, and my team, I'll give that to you one more time. employmentlawyer.ca. It's very easy to remember that. That's why we use it. employmentlawyer.ca. All right. So Carolyn has our next question. Can you please talk a little bit about constructive dismissal due to toxic environment? Do I pursue severance? I got nothing, and ROE stated I quit. Thank you. So everyone has the right to work in a harassment-free work environment, to work in a healthy and a positive work environment. So what happens if, despite that, your employer's created a toxic work environment, or you're harassed or you're bullied, the law says you don't have to continue working in that situation, right? You don't have to continue working. You can leave, and that's a constructive dismissal. The law considers that to be a termination, which means you're owed your severance. Now, the trick here, the key part of this is you have to be able to prove the toxic work environment. Remember, your employer is not going to admit it. If you're being harassed or bullied, the person that's bullying you is not going to admit that they've bullied you, right? So the question becomes, how do you prove it? Do you have emails or text messages or documents? Is there a witness? Is there a recording? But if you can prove the toxic work environment, it's actually very simple to pursue constructive dismissal. But always understand that it's not necessarily going to be enough for your word against someone else's. So it can be, but generally speaking, it's not enough. You have to prove what you're saying. The company doesn't have to disprove it. You have to prove it. But if you have a way to prove it, very easy to pursue it. I want you to call me right away, okay? And I'll help you pursue it. I'll help you get the severance that you're owed. But my first question to you is always, how do we prove it? What do you have to establish that toxic work environment? Why do we have to establish the reason that you left, right? Because they're going to say you just quit because you didn't feel like working here, or because you wanted to spend more time with your family. How do I prove differently? Okay, how do I prove that there was a toxic work environment? So if you have that ability to prove it, easy to pursue, happy to help you. So hopefully that helps, Caroline, to connect with me. Easy. Again, employmentlawyer.ca. Again, employmentlawyer.ca to do that. Happy to help. I'm here, and my team is. You got last few minutes. You can still get in a question under the wire. So let's do that. Next question from Matt on Facebook. The small business I work for has been sold, and the new company has offered me a job at the same rate of pay. What kind of severance am I entitled to, if any? So if you continue working with the buyer, then you're not owed any severance, okay? Because you continue working, they inherit your service, and you're not owed any severance. If you decide not to take that, to take the offer, even though it's a good offer, but you just don't want to, you're going to be entitled to your minimum severance. And that could be as little as a week per year of service to a maximum of 8 weeks. But the best thing to do is to call me so I can look at your specific situation. But if you continue working, severance is not going to be owed. Hopefully that makes sense, Matt. All right, let's see. Our next question from Facebook, Kevin has a follow-up. Kevin says, what happens to my vacation time while on short-term or long-term disability? Do I get paid for the 2 weeks or 4 weeks now that I have reached 10 years? So if you have accrued vacation pay, you can ask for it to be paid out. Okay, you can ask the company to pay it out now. You don't have to wait if you have accrued vacation pay. So if there's vacation pay in the bank, so to speak, you can ask them to pay it when you come back down the road, or you can ask for them to pay it now. It's fine, no problem. It's your decision. They'd have to pay it out. Hopefully that makes sense, Kevin. You know what to do. employmentlawyer.ca if you have any questions. All right, let's see. I think the last question of the day is going to be from Chanel on Facebook. If someone felt that they needed to resign because workplace accommodation for their special needs child were being removed, are they entitled to constructive dismissal after the fact? So if I understand the question is, you have a special needs child and your employer was accommodating you by maybe giving you some flexible hours, giving you some flexibility so that you can care for your child, and they decided to stop doing that. Well, that would be a human rights violation. We call this accommodation based on family status. If you have a child that needs your help and support, and the only way you can do that is by your employer accommodating you, the employer has to provide that accommodation. They can't just decide, well, we did it for a while, we don't want to do it anymore. That's a human rights violation. So their refusal and you're resigning because of that, yes, it would be a constructive dismissal, but you would also be owed additional damages, human rights damages, because what the company did is illegal. So yes, we call this, again, family status accommodation. So sometimes it arises in the context of childcare. Let's say you're a single mom, as an example, and you have to be able to take your child to school at a certain time. You're the only one, etc. Well, your employer may have to be flexible and allow you to start a bit later so you can take your child to school. And if they don't accommodate, that's illegal. Hopefully that makes sense. Last question, I'll do that very quickly. Raj, is it legal to record a conversation? What if the other person denies to record? You're not breaking any law by recording a conversation that you're part of. You can't record other people, okay? People that you can't record people where you're not speaking to them. You can't leave a recorder and record two people speaking. But if you're speaking to someone, you can record that even if they don't know. You're not breaking any laws. If the person refuses, I guess they're not going to talk to you, okay? So you have to make the decision. But you're not breaking any laws by recording a conversation that you are part of. Guys, this is the time that I have for today. Now, my colleague, Alex Lucifero, will be back tomorrow, Thursday, the 23rd at 12 p.m. Eastern, right here to answer more of your questions about employment law. He'll also talk about disability law. So he'll be back here tomorrow, Alex Lucifero, at 12 p.m. Eastern. I'll be back next week as well, myself, Lior Samfiru. But don't wait until then. In fact, don't even wait till tomorrow. Don't even wait till this evening. If you have follow-up questions, if you need help from us, reach us right now through employmentlawyer.ca. Again, employmentlawyer.ca. You can connect with us by phone, by email, through a form, whatever you want. Guys, thank you very much. Again, I'm Lior Samfiru. It was always a pleasure to be here with you. It always is a pleasure. I'll be back next week. Thank you for listening. Thank you for asking questions, and we'll talk to you all very soon. Take care.